I'm Annie Fitzsimmons. I'm your Washington Realtors Legal Hotline lawyer. And today we are once again reaching into the Legal Hotline mailbag to bring you a question and answer for discussion. Today's question goes like this. Seller listed the property and buyer made a full-priced offer. Seller, however, expected a bidding war and wants $5,000 at least over the list price. Buyer refuses to bring a higher offer. Seller is rejecting buyer's full-priced offer. Does anybody have recourse? And if so, whom? If you'd like to push pause, we'll come back with the answer. The answer is yes, there is recourse available. Who has recourse is a different question. Let's start with the buyer. Does the buyer have recourse? Whether the buyer has recourse depends upon whether or not the seller violated the fair housing laws, either state or federal, by rejecting the buyer's full-priced offer. If seller rejected buyer's full-priced offer because buyer is a member of a protected class, then buyer certainly has recourse under the Fair Housing Act. I'm assuming that's not the case because the facts of the question were that seller reacted only to the price, that seller wanted more than the list price. If that fact can be established by the seller, then buyer has no recourse. Seller is not obligated to accept any offer that any buyer makes, even if it's a full-priced offer. So setting aside any potential claim for the buyer, there is still potentially recourse available, and it would be to the brokers. And we don't need to dissect the difference between the listing broker and the selling broker because both brokers have potential recourse available to them. When seller listed their property with listing firm, seller signed a listing contract that said to the listing firm, if you bring a ready, willing, and able buyer on the price and terms set forth in this listing agreement or on other terms acceptable to me, then I will pay you X amount of dollars, the compensation established in the listing agreement. In the statewide form listing agreement, it goes on then to talk about a sharing of compensation between the listing office and the selling office. That issue is not all that significant in the response to this question. What this question really looks at is, does seller become obligated to pay the compensation offered or agreed to as part of the listing contract based on the fact pattern presented? And the answer is, I don't know. And the reason I don't know is because I don't know what any individual court would say about this. There are some courts who will say, yes, compensation is owed, and others will say it's not. Here's how the litigation would go at its most bare bones. Brokers, or the firms, and it could be listing firm or selling firm, or one or the other, and there is some further discussion that would be required to say, let's go with the selling firm only, but that's discussion for another day, and really that's discussion between the selling firm and their legal counsel. I will tell you it's entirely possible for the selling firm to bring the lawsuit against the seller, but it's a much more complicated and legally technical issue. If you're going to file a lawsuit, you're going to discuss that issue with your lawyer anyway. So let's assume that either firm or both firms are bringing a claim against a seller, and the basis of their claim is, seller, we produced a ready, willing, and able buyer on your price and terms as set forth in the listing agreement. And remember that the seller's price and terms include the attached data sheet that's referenced in the statewide form listing agreement, and it includes things like the property description, number of bedrooms, number of bathrooms, but it also includes some of the seller's terms, like will they accept a VA offer, an FH offer, et cetera, et cetera. Certainly, the listing agreement does not give every term that a seller is going to consider in accepting their offer. So brokers say, we brought a full price matching terms offer. Seller defends by saying, no, you didn't. You brought a full priced offer, But I have terms that I was expecting this offer to include that it doesn't offer, that it doesn't include, and that were not specified in the listing printout. For example, I wanted more earnest money. I wanted a different closing date. I didn't want to have an inspection contingency, and on and on and on, because there are a number of features of any offer that are not identified in the listing printout. Some courts are going to say, seller's right. This is not this offer does not earn compensation based only on the listing agreement because seller rejected not just the price but some of the terms from the buyer. Other courts are going to say that the court will impose a reasonableness standard on the seller because every party who's subject to a contract is subject to a good faith obligation to perform the terms of that contract. So seller, it's not reasonable to say that if the buyer offered an industry-wide reasonable amount of earnest money, that's reason alone to reject the offer. Or if the closing date is within a reasonable date, then that's not a reason. Most buyers and most sellers anticipate that a buyer is going to include an inspection contingency, so that's probably not a good reason. Courts can go either direction on this analysis of the fact pattern, and that's why I can't tell you whether or not a broker is entitled to compensation. Certainly different fact patterns leading up to the lawsuit are going to make a stronger case or a weaker case. And so if you are in this situation and you are looking at the question of whether or not you should pursue a seller for compensation, all that I can suggest is that you talk to your legal counsel. Ask them to help you understand whether or not you have a viable claim and whether or not the pros outweigh the cons, because believe me, in every piece of litigation there are substantial cons that have to be evaluated. One more thing to know, just because the seller rejects this offer, if the seller tomorrow or the next week or even 2 or 3 weeks from now, using the same listing agreement, sells the property to another buyer, then that first buyer's broker is not going to have a viable claim, because the listing agreement and the MLS rules contemplate that every seller is only going to pay compensation once under every listing agreement. So if the seller ultimately sells the property based on this listing agreement, pays the compensation required by the listing agreement, even though it's not to the first buyer even though it's not to the first buyer's broker whose buyer wrote a full priced offer, seller's still not going to be required to pay 2 sets of compensation. If you have questions on this or any other topic, please send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtors member.